I would like to shout out Kevin Smith for sending me this story, but before I get into the story, we're going to read this definition. It says, qualified immunity is a legal doctrine in United States federal law that shields government officials from being sued for discretionary actions performed within their official capacity, unless their actions violated quote unquote clearly established federal law or constitutional rights. Now, the reason why I read that definition is because this is what this story is going to be about. So there was this incident that occurred and it involved some police officers and $225,000. Now that $225,000 did not belong to those cops, but they did indeed steal the money. They got shielded by the qualified immunity, I guess you can say, terminology with a judge. And because of that, they are not even going to press charges against these cops. So basically, these cops just basically got away with robbery. They stole this money from somebody else. And I'm guessing maybe they was a suspect in a crime that they were, for what they were doing or investigating or what have you, but they were still able to keep the $225,000. As far as I'm concerned, not only did they steal that money, that was also evidence. So when people say that police have some of the most dangerous line of work, look to stories like these and realize that that is not the case, at least not in every situation in the way that they over exaggerate it. Now I'm going to go ahead and read this article coming from reason.com so we can get more additional information about this. It says the U.S. Ninth Circuit Court of Appeals has ruled that Fresno police officers accused of stealing more than $225,000 while executing a search warrant are protected by qualified immunity and thus cannot be sued over the incident. While the unanimous panel acknowledged that the city officers ought to be recognized that the alleged theft was morally wrong, it concluded that they did not have clear notice that it violated the Fourth Amendment. In other words, the cops weren't equipped with enough information to deduce that robbing people is a violation of their constitutional rights against unreasonable searches and seizures, a bizarre interpretation of the law to say the least. So what they're basically trying to say is they claim these grown officers, these grown men and or women or both, whoever was there, claim that they did not know stealing was a bad thing. Now, what does that remind you of? Does that remind you of Ethan Couch, who got hit with that affluenza thing, saying he was too young and rich to know that stealing a car, driving underage, and having a DUI and hitting four people was morally and very extremely wrong, severely wrong. That's basically what they're saying right here, that these guys or whoever it was that took this $225,000 were not knowledgeable enough that stealing was wrong. If they don't know stealing is wrong, why the hell do they even have a job? First of all, that doesn't matter what department or what line of work it is. That's why I say, when it comes to morals and how they try to throw morals onto us, that's why I completely shun that, because you have cases like this. That's a bunch of bullshit. They know what they did was wrong, but they want to play dumb. It says, let's see here. In 2013, the Fresno Police Department carried out a raid on Micah Jessup and Britton Ajan. I probably pronounced their name all wrong, who were suspected of operating illegal gambling machines. Neither man was ever charged. Upon completing the search, officers provided both with a ledger maintaining that they'd seized $50,000. Jessup and Ajay alleged that in reality, the cops made off with $151,380 in cash and $125,000 in rare coins. Both men contend that the officers pocketed the difference between the funds reported with the warrant and the total amount they took, amounting to $226,000 and $226,380 theft. Even so, the panel granted qualified immunity, a legal doctrine that, in the words of Reason C.J. Ciaramella, allows public officials to violate a constitutional right. And you know, I'm so glad that we're learning about this right now, because some people did not know that something like this existed, which now explains so much. So long that so long as that right has not been clearly established by current case law. In theory, it protects civil servants from undue harassment. In practice, it allows those officials to get away with behavior that would land a normal person in prison. No wonder so many of these fools out here want to be cops, because they probably looked up what this was and realized they could be protected. I tell you, the law enforcement has the most invincibility and immunity than any other job in America. Like, they are literally like the grassroots level of what Congress probably is, because Congress probably operates under the same thing. Writing for the panel, Circuit Judge Milan D. Smith Jr. cited Brewster versus Beck, a Ninth Circuit precedent, and insufficiently applicable to a Fresno case. In that decision, the court ruled that officers who impounded a vehicle in an asset forfeiture seize, another repugnant practice, violated a woman's Fourth Amendment rights after she furnished a valid California's driver's license and registration. The police seized the car because she had a suspended license. But that doesn't pass muster here, said Smith. Brewster, he wrote, involved the seizure of a property pursuant an exception to the warrant but requirement. But in Jessup versus City of Fresno, the officer seized appellant's property pursuant to a warrant that authorized the seizure of the items allegedly stolen. Smith also argues that the former case pertains to impoundment while the latter surrounds theft. That renders the decision a useless comparison, he says. Notwithstanding the fact that outright stealing is arguably an offensive transgression, but the nail in the coffin is that Brewster was decided in 2017, 4 years after the Fresno officers allegedly robbed Jessup and Ajain. Even if the president adequately aligned with Jessup, Smith argues the officers didn't have that case law to guide them. Smith rejected the plaintiff's 14th Amendment claims on similar grounds, writing that the Ninth Circuit has not held that officers violate the substantive due process clause of the 14th Amendment when they steal property seized pursuant to a warrant. Well, at least cops won't be able to use that excuse anymore, right? I'm afraid not. The judges demurred at the opportunity to issue a definitive ruling on whether the Fresno police violated Jessup and Ajain's rights, leaving the door open for another public servant to come along and do the very same thing. Like I said, this is why they are flocking to these police departments when you have stuff like this that protects them. And they say that they have the most dangerous job in the world. I beg to differ. As a matter of fact, many stats beg to differ as well, because I don't even think police officers, as far as dangerous jobs, even cracks the top 10. It really doesn't. Like, you can look up any top 10 dangerous jobs and I don't think they are in the top 10. But I learned something new today, because I didn't know something called qualified immunity even existed. Now I know the definition, and now I know what happens with this. So basically, it's just them saying that they do something bad and they claim they don't know what they did. In this case, they stole something and then they claim they didn't know that stealing was a bad thing. That just means y'all got a bunch of fools working up in there, but they're not stupid though. They know exactly what they're doing, and they're very tactful when it comes to this, and very crafty at the same time. Y'all let me know what y'all think about this down in the comments, and I'll talk to you in the next one.